If you were arrested for domestic violence and received a one-page document called an emergency protective order, you either got it in jail, it was read to you in jail, or you got it when you were getting out, then this video is for you because I'm going to be explaining what that document is, what it means, and most importantly, what it means about what the alleged victim told to the police officers. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you from start to finish how to win your restraining order hearing if you were served not just with an EPO, but also with a temporary restraining order that has a hearing date. And if that is something that you need help with, you can get your free first class via the link down below. Okay, so let's jump right in. Let's talk about emergency protective orders and what they mean for you, your case, and what the alleged victim said to the police. An emergency protective order is typically a protective order that is issued when law enforcement, when a police officer asks for it. Typically, how it works is that when the police come out to investigate a domestic violence allegation, and I put that in quotes because typically they know, at least in the state of California, that they are going to be arresting someone even if they don't really see any evidence that domestic violence exists. So I don't really consider that an investigation. But what law enforcement will do when they come out is they will ask the alleged victim if they want an emergency protective order. So this is once they've determined who they are going to arrest, typically the male involved in the scenario, if there is one. And what a lot of people don't realize is that that emergency protective order is only issued if the alleged victim says yes and has told police officers that you engaged in domestic violence. Specifically, the only way that they can get this is if a police officer informs a judge that they believe that the alleged victim is in immediate and present danger of domestic violence based on that person's allegation of a recent incident of abuse or threat of abuse by the person against whom the order is sought. That means that the alleged victim, the protected party in the emergency protective order, told police that there was abuse. Now, I've seen this all the time from potential clients, from sometimes people who leave me comments on YouTube, from clients who say, oh, the alleged victim wants to drop charges. They don't know why I got arrested. They told the police that I didn't do anything wrong and that if anything, they were the aggressor. But an emergency protective order was issued. That to me is a major red flag that the alleged victim is probably lying and probably did allege to police officers that there was abuse or a threat of abuse, not that they were the aggressor, not that nothing happened. And I'm saying this because a lot of people get back together with that person, sometimes in violation of the emergency protective order, which typically lasts between only 5 and 10 days, believing that the other person was totally innocent in all of this. It was just the cops who got confused or who had this directive that they have to make an arrest whenever there's domestic violence. And it wasn't because of anything the alleged victim said. The alleged victim will say, I'm 100% on their side. I have no idea why this happened. You can't trust that person. They did make allegations against you almost certainly, and so you need to take steps to protect yourself. If you need help with your criminal case, feel free to give me a call. You can also find my number and a link to book a consultation down below. And if you did find this helpful, please don't forget to like, subscribe, ring the bell, and subscribe to me on TikTok, Instagram, and Facebook.